long she met with the defendant? Has there been testimony regarding that already?
She has testified that she met with the defendant on several times. There has not been a precise number or quantifiable time frame that she spent.
I'm going to sustain the state's objection.
Motion to strike the conclusion.
Let me return to the scene. You also mentioned some earlier interviews with Mr. Draft. How long did you spend with Mr. Draft during those interviews?
I spent extensive amounts of time with Mr. Draft interviewing him. I spent well over 10 hours interviewing him, and those 10 hours worth of interviews occurred over a period of a couple of months.
Why did you interview him so many times, Dr. Johnson?
Well, according to the research that I have done in my expertise in my field, it's absolutely pertinent to not only conduct the exam, but to follow up with your clinical judgment to ensure that the personality conforms with the test results and to do an independent analysis and investigation.
You were in the courtroom when Dr. Trish testified earlier today, correct?
I was.
And you heard that she spent a half an hour with Mr. Draft, correct?
I did.
In your professional opinion, can you explain to the jury the adequacy of her examination?
Well, I'm sorry, Chacona?
Chacon.
Dr.
Objection. This calls for an improper characterization. It's the adequacy of Dr. Chacona's review.
Talk to me a little more about that.
To express her opinions on the adequacy of Dr. Chacona's reviews and tests, this would be an improper characterization of the evidence that Dr. Chacona has already admitted while under oath and testifying that this was based on sufficient facts and data. They used principles and methods reasonably relied upon in his field and to a reasonable degree of scientific certainty. There's an inadequacy involved in that would be an improper characterization of the evidence.
Your Honor, a witness and their opinion, the veracity or credibility of a witness and their opinion are always an issue here today. The self-serving evidence that Dr. Chacona presented that suggested that her opinion is based upon reliable and sufficient professional judgment can certainly be cross-examined through an opposing witness, which is what these questions are elicited to do here. The witness, Dr. Chacona, has already testified that she believed that her testimony and her opinion were based upon sound scientific judgment. The questions are merely presenting a witness that opposes that.
I don't think we need Dr. Johnson's opinion on Dr. Chacona. I think the jury's the one that's going to have to render an opinion on it. So I would sustain the state's objection.
That's right.
You mentioned earlier a psychotic V, correct?
Yes.
It exhibited itself in the MMPI results. What is that MMPI? What does a subject that exhibits a psychotic V, what are some characteristics we can expect to see in them?
The characteristics consistent with a psychotic V
Correct.
are an individual who is impulsive, hostile, aggressive, who can't be predicted to know the difference between right and wrong and act in conformity therewith.
And you also asked Mr. Draft questions about what happened on May 13th and May 14th, 2011, correct?
I did.
Objection leading.
Your Honor, this is a preliminary question.
Yes.
I did.
And what did you find about his medical state on May 14th, 2011?
Well, I found that he was already predisposed to criminal conduct, and of course, as my test regarding the MMPI indicates, Mr. Draft is predisposed to highly protective impulses. So essentially, what happened is that he just snapped on the date that he read that Twitter feed that his daughter exchanged with her boyfriend. He had a very, very strong relationship with his daughter. He informed me throughout the course of his interviews that he and his wife had gone through a divorce many years prior and that he had been given sole custody of his daughter. He therefore had a very, very strong protective relationship with her. So when he found out that this 22-year-old was engaging in sexual conduct with his 17-year-old daughter, basically it's like a natural instinct that kicked in where there's a predator going after his
Objection.
offspring.
Answers become non-responsive in narrative.
Let's ask the question.
Based upon your knowledge of Mr. Draft's medical state on May 14th, 2011, and your analysis of the MMPI results, what did you in your professional opinion, caused Mr. Draft to snap?
It was triggered by the reading of the Twitter feed and the knowledge that his daughter was engaged in a relationship with an adult male, and his reaction that is consistent with the behavioral results that the MMPI yielded, which is that he became dizzy, he fell, and he was apparently not in control of his facilities.
Based upon your knowledge, education, and experience, and your review of all the information in this case, have you come to a conclusion within a reasonable degree of medical certainty as to whether Mr. John Draft possessed a mental disease or defect on May 14, 2011?
I have.
And what's that conclusion?
The conclusion is that Mr. Draft suffered from a mental disease or defect, and that due to that disease and or defect, he lacked the substantial capacity either to...
Objection. Rule 704B prevents an expert from testifying as to the ultimate issue. In this case, she's testifying as to the mental state and the ability of the defendant to control his actions and conform to the requirements of law at the time of the crime, which is specifically prohibited by Rule 704B and usurps the role of the jury.
Your Honor, at this point in time, the witness has testified that Mr. Draft does possess a mental disease or defect, and that mental disease or defect occurred on May 14, 2011. Her expertise in forensic psychiatry and her understanding of the laws and their interplay with medical science would allow her to express an opinion as to what effect that mental disease or defect could have on Mr. Draft's ability to conform to law. We are not usurping the realm of the jury because we have qualified this opinion as to a medical duty of certainty. Therefore, it would satisfy a forensic psychiatrist's evaluation. However, may it not be enough to be accepted by the jury, and for that reason, we have not infringed upon their terms.
Your Honor, the conclusion that John Draft had or possessed a mental disease or defect, the state will concede is a valid conclusion allowed under Rule 704. However,
So that will be admitted.
to continue on and say that he then lacked the substantial capacity to appreciate his actions is usurping the role of the jury. That is the role of the fact finder alone. And to testify and put that evidence and testimony on the record would violate Rule 704B.
Do you have any response to just that last section?
Your Honor, we have sufficiently qualified the expert's opinion as within a reasonable degree of medical certainty. The jury has no way of knowing how this mental disease or defect could affect Mr. Draft or his decisions thereof. This information is helpful to the jury. The witness possesses the necessary expertise and was admitted to this court without objection as an expert in forensic psychiatry.
Yes, Your Honor, indeed, she has the requisite qualifications, and her conclusion it also passes 702. However, this still must pass the bar 704, which specifically forbids conclusion regarding the defendant's ability to control his conduct or the mental state that constitutes an element of the crime. So again, while she may have been admitted as an expert and her conclusion is valid, they are still prohibited by Rule 704.
I'm going to agree with the state. I'm going to sustain the objection only as to whether or not the defendant did have the substantial capacity to conform to the letter of the law.
And motion to strike those portions.
Motion to strike.
Dr. Johnson, have you come to a conclusion within a reasonable degree of scientific certainty based upon your knowledge, education, and experience as to whether Mr. John Draft possessed a mental disease or defect at the time you examined him?
Yes.
And what was that conclusion?
The conclusion was that he, for lack of a better word, he's insane.
No further questions, Your Honor.
Objection. In proper opinion, the word insane has a legal connotation, and this is a legal conclusion made by the expert.
Untimely, Your Honor.
Just happen to sit down quickly.
I will ask the doctor, can you clarify that for us?
By insane, I mean that he was mentally incapacitated.
Thank you. And the word insane is straight.
Dr. Johnson, you wrote an article related to the MMPI testing you mentioned under examination, correct?
I did?
That was entitled, Murder on the MMPI, Express Use and Abuse of the MMPI in Criminal Minds. Did I read that correctly?
You did?
You mentioned there are two common misapplications of the MMPI test, like the one you performed on John Draft. Isn't that right?
That is?
One of